America. This is Stuart Ryan with another example of foolery in the Ryan Report, trying to comment on current events, catching them as quickly as I can. And it's once more into the breach, because the federal district judge in California, Charles Breyer, has made an important decision in the Newsom versus Trump case, in which he found that Trump has violated the Posse Comitatis Act of 1878 by his deployment of National Guard and military troops into the streets of Los Angeles. Now, Trump had justified, or rather rationalized, his actions by invoking 10 U.S.C. Section 12406, a subset law not as powerful as the Insurrection Act. But this statute grants the president the authority to call a state's National Guard into federal service under very particular circumstances, where the president can federalize the National Guard under the same conditions as the Insurrection Act, but ultimately without its real strength. The act applies only when the U.S. is invaded or in danger of invasion by a foreign nation, no, or when there is a rebellion or danger of rebellion against the authority of the United States government, no, or when the president is unable to enforce the laws of the United States with regular forces alone. No. However, when those conditions do not exist, as in this case, it is inherently unconstitutional and against other federal statute law in its application, and is specifically in violation of the Posse Comitatis Act of 1878, which strictly prohibits the use and deployment of federalized National Guard and or military troops into civilian law enforcement or other use within the streets of the United States and its cities. And so, Judge Breyer has once again, as he had previously in his first hearing of the case, issued a fresh injunction against defendant Trump, stopping the present deployment from taking a number of actions. And here we are remembering that the original jurisdiction and injunction issued was overturned by a 3-judge panel of the Ninth Circuit Court of Appeals, where the injunction was stayed, with the case remanded back to Judge Breyer in the trial court, where the issue had become whether or not the government had violated. Now, Trump once more will undoubtedly appeal the Breyer decision to the Ninth Circuit Court of Appeals, where hopefully we'll not get the same panel that heard the initial case as to injunction or the staying of the injunction, because they made an absolutely moronic and legally unsupportable decision in staying Breyer's original injunction order, using the outlier legal concept of judicial deference, of which I have spoken often and made at least 2 or 3 podcasts about, as a means to rationalize their per curiam decision. All they really accomplished was to continue the irreparable harm being done to the citizens of Los Angeles and California by threats and intimidation. While this may be an important decision from Judge Breyer, it's only one battle in the war, one battle against the imposition of a militarized police state, and we have no guarantee that Trump will not attempt to invoke the Insurrection Act, a much more powerful act of 1807 or 1808, which is the sole means of arguing a possible exception to the Posse Comitatis Act. By his concocting one kind of national crisis or so-called national emergency or another, alleging or claiming he, given judicial deference, can as president deploy the military in a civilian role, although he would then have to have precedent overturned, going back to the Civil War and the case of ex-party Milligan. He could have this done by a complacent and fascist Supreme Court, who have continuously favored him in all the cases coming before them, and of course we know how they've granted him perpetual immunity from ever being prosecuted for anything. In the interim, I would advise all governors, especially in the blue states, and I'm thinking about Pennsylvania and Chicago, to be urgently proactive and call up their own bloody National Guards right now with orders to repel any possible invasion by Trump and his unlawfully ordered federal troops, prosecuting them for state crimes, as D.A. Krasner has suggested, the D.A. from Philadelphia, should they breach state borders. There are, under states' rights and federalism, concrete justifications for governors to take such actions and to refuse federal government intrusion into their respective sovereignties. After the fact, litigations are just not acceptable as anything more than humble pie, obscure, remedial, and ineffective attempts to restore balance, order, and the rule of law in our country. So there you have it, folks. Enjoy your day. Remember to subscribe, as I need you all the support I can get. I need your support in bringing truth to power without fear or favor.